I'm here.
Yep. Okay, folks. Let's see who all we have. Yeah, well, I mean, we'll get to it. The question will answer itself momentarily, I think. All right, everybody. Is that,
Yeah. What?
is it Mr. Yunt? Are you over in Whitley County?
Yes, sir.
Yeah, all right,
This is
good
where
deal.
I'm from. Yeah.
All right. Well, I can go ahead and call that one first then, because that's the only case I have for that particular facility. We're recording and streaming. This is a motion filed by the Commonwealth to revoke probation on the basis of a probation violation report that we received sometime back, and then also a supplementation to revoke probation, adding their some additional charges that came after the original motion was filed. Let's see, is this Mr. Gardner?
It is, Your Honor.
Mr. Gardner, are you asking for me to set this for a hearing?
Yes, Your Honor.
Okay. We received, back when we did this originally, there was Mr. Wren was the attorney. We received an email, I guess you received that too,
Yes.
with him saying that he didn't know whether he was going to be employed to represent Mr. Yunt or not. And if we were going to reschedule it for a hearing, he would let us know before that hearing. Does that sound right? Is that what they?
Yes. But may I ask a question?
Yes.
How much time is it that I've got to do? How much time on this?
I don't even remember. Mr. Gardner, do you
I
have?
think it was a year.
Yeah, I don't have his,
I think it was just a state
Find
year.
out. Yeah. Let's see. If you'll let me find your sentence was a year.
Yeah.
That,
I was walking on the road crew at Barron County and got caught with some stuff that was in a bag. Yeah.
yeah,
Okay.
you got a 1-year sentence on 2019. And, so, yeah.
I'm still here. Okay. On that, man, I got another question. If I get revoked, how much more time do I got to pull? Am I getting, I've done time on this twice already. So I'm trying to figure out how much time do I have to pull? I don't want to pull the time. I'd rather be on probation because that keeps me in line. I came in sober this time. I've got a job. I've taken care of my kids. That's the first time in my life I've ever been able to do that.
To answer your question, you should get credit for when you get arrested in a case and like, for example, when you get arrested on a warrant for this case, which has happened twice, for probation revocation motions, you should get credit for that time. The only, I guess, complication to that is that I don't know how much credit I don't know what credit you're entitled to because I can't count that up. I don't know,
Okay.
where you've been and all that. But like right now, it looks like your new arrests were just misdemeanor arrests.
Yeah, I don't catch any more
Any
felonies.
problem, you'd get credit for everything since that arrest. If you were arrested on a felony, you might only get credit in one case rather than in both cases. But in a misdemeanor, you get credit, because your misdemeanor time runs concurrently automatically, no matter what. So you'd get credit from whenever you got arrested till whenever, you got revoked,
Okay.
if that's what happened. And then the first time you were in there for a little while, so you get credit for that.
Yeah.
You probably would not get credit at the original charge because you were already a state inmate
Yeah.
when you got that charge. So you won't get credit against your state sentence and then against this pre.
Okay.
Did you do a rocket docket? Did you do a rocket docket?
Yeah. I was in Marion and I was in a SAT program. I was a substance abuse teacher. I was mentoring, and I was already at the end of my sentence. I'd done 42 months on a 5-year sentence because of this case. I never got to work again. So I got to do almost every day of it. But yeah. I mean, I've actually, believe it or not, I know every convict says this, but I came in sober. I've got proof of a job, I have income. I'm finally allowed to even hold my daughter for twice a week. I'm actually doing good things. But I'm still a convict. Don't get me wrong. I'm still who I am. I've done time. I've done my problem. But yeah, but like if you all can look at me compared to what I used to look like, you all be like, man, the guy's trying. I mean, at least he's trying. He's giving him more effort than most convicts that go out here and just go straight back to doing drugs and selling drugs and doing. I mean, I'm actually giving. I got an ex that runs 2 different NA meetings twice a week, and I'm there pouring coffee. Like I am trying. And they said I ran from the law on foot. Okay, I didn't.
Wait, hold on. You don't want to talk about that right now.
Okay, yeah.
Yeah. All right. This is what I'm going to do. We'll set this for our next hearing date, which is 2 weeks. If Mr. Wren is going to get involved on your behalf, he'll need to be notified of that.
I don't know if he's going to or not, sir.
Because I don't know either. That's why I use the word if, because
the money I do got.
Email and said if some money comes my way, I'm going to handle it, and if not, I'm not. So that's a unknown future event, right?
Okay, so if I ask to be revoked today, you don't really know how much time I got to pull.
I can't tell you that. I mean, not that I don't want to tell you. I just can't tell you.
You just can't tell me.
Yeah, I can't. I mean, I could make up a number, but then that would be.
I'd rather not do that.
Yeah, that wouldn't help you much. Yeah, but I can tell you this: we can put it all. I mean, we're going to have to put it off 2 weeks, and I mean, there may be some way to get those days figured up somehow between now and then, so that so that you would have a number at that time. Let's see. That is February. What is today? February 8th, 9th. So is that going to be the 23rd? Yeah, it's Tuesday. So the 23rd, that's what our hearing date will be. Mr. Gardner, the only thing I can tell you about this, if you'll help me try to remember, if you get an email from Mr. Wren that says he's not going to be doing this, he said he would file a notice in the record, but sometimes that doesn't happen. You might notify the DPA, because they'll want to, I'll have to appoint them, and I don't want to make him wait another 2 weeks when we get here in 2 weeks.
But Judge, do you want to go ahead and appoint him now? I mean, it sounds like Mr. Yount's saying that I don't know if he can.
Yeah, all my money's going to my daughter.
Okay. All right. Yeah, that's fair. Mr. Barry, let me go ahead and appoint somebody from your office. Mr. Yount is in Whitley County Detention Center. He'll probably still be there in 2 weeks. And like he said, he's got a 1-year sentence, which he's got some credit coming to him because he's gotten arrested on this while on probation 2 different times. So those days will get credited,
Okay. It's be Ms. Myers will be representing him.
All right. So, Mr. Yount, we're going to put you down for 23 February.
Okay.
That'll be at 1:30. We'll send something to the detention center it'll be 2:30 to you guys over in Whitley County, but
I don't know. I've learned all about y'all. This time's difference.
Yeah. Okay.
Okay.
All right. See you then.
Thank you. Have a good day. See you guys.
I don't seem to have any other jails on here. So, let's see, Samuel Brown. Mr. Brown, where are you?
Yes, sir. Here in Barron County. I'm at home
okay.
right now.
You're at home?
Yes, sir.
All right. I'm gonna get your file. We'll go ahead and knock that out. Is that an arraignment? Okay. Mr. Brown,
Yes,
this is an arraignment, okay? And a
Yes, sir.
remnant is where I make sure that you know what you're charged with, and I make sure that you know what your rights are. So
Yes, sir.
my first question to you will be, do you feel like you're going to need me to appoint an attorney for you, or are you going to employ your own attorney?
At this time, I'm going to need one appointed too.
Okay, so you want me to appoint one? You're kind of cutting in and out, so I'm trying to make sure that I'm hearing you.
Yeah.
You want me to appoint you an attorney?
Yes, sir.
All right. Mr. Brown, can you tell me your address?
4127 Drinking Springs Road, Glasgow, Kentucky.
Okay. I believe that is the address that we already had.
Yes, it should be.
Is there a unit number? Charm. All right, well, we've lost Mr. Brown. All right, we're gonna have to move on.
Are you there? You're on?
I'm here, but you're not.
Yeah, I keep losing signal out here, sir.
Yeah. Do you have somewhere that you can go and access anything that's Wi-Fi?
No, not right now, not at the moment, sir. You got me now?
I do have you now, but I can't expect that the immediate future is going to be any different than the immediate past is going to be in terms of quality
Right.
connection here. Look here. Why don't you
Yes, sir.
why don't you log out and try to log back in? I'm gonna move on to something else, and then we'll try to come back to you. Okay. Mr. Bell, what do you have in mind? You have some folks that are out of custody, right?
Yeah, we got a couple of pleas, Judge, we sent over already, and then, I've got Stephen Ginter, but it doesn't look like we're gonna be able to do him today. He's over Marshall County, of course.
We've had very limited luck getting Marshall County to.
Yes, sir.
Judge, the two pleas that we have are for Joni and Ryan Hawkins, and I filed those about 20 minutes ago. There you go.
Got them right here.
Judge, there's only one mistake. It's a minor error. The date on there still says 2020, but I mean, I just put 2021 when I signed it, so.
I see. Yeah.
I do have a motion concerning these whenever it pleases the court. I guess it'd be after the end of the plea.
Okay. You all, Mr. and Miss Hawkins, are you all prepared to go forward right now with your plea?
Yes.
All right. Miss Hawkins, we're going to start with you. Will you raise your right hand? Do you swear or affirm that you'll tell me the truth, so help you God?
Yes.
All right. Ms. Hawkins, in my hand here, I have a motion to enter a plea of guilty. It looks like this right here. Does that look familiar?
Yes. Yes.
And it has a signature on it, which looks like it might be yours. Is that right?
Yes, sir.
Okay. In addition to that, I have a plea offer from the Commonwealth. Again, does that look familiar?
Yes, sir.
All right. Is that your signature?
Yes, sir.
Did you read over both of those things before you signed them?
Yes.
Do you feel like you understand them?
Yes.
Did you get the opportunity to discuss them with your attorney?
Yeah, I
All
did.
right. Ms. Hawkins, do you understand that nobody can make you plead guilty? If you plead guilty, that has to be a decision on your own. Do you understand that?
Yes, sir.
All right. Do you feel like anybody is making you plead guilty today?
No, sir.
You understand that by pleading guilty, you waive the following rights: the right not to incriminate yourself, the right to a speedy and public trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses, the right to put evidence on in your defense, and the right to appeal.
Yes, sir.
All right. Do you feel like your judgment is impaired today for any reason?
No, sir.
Do you feel like that there is any other reason that I may not be aware of that you should not proceed with this today?
No, sir.
All right. In this case, the Commonwealth is making the following, or promising to make the following recommendations if you plead guilty. Count one, possession of a controlled substance, first degree, first offense. The Commonwealth is agreeing to dismiss that on a plea to the other two charges. Count two, drug paraphernalia, a Class A misdemeanor. Commonwealth would recommend a 12-month sentence. Count three, possession of a controlled substance, third degree, another Class A misdemeanor. The Commonwealth would recommend a 12-month sentence. Those sentences would run concurrently for a total of 12 months, plus the possibility of a fine up to $500 in court costs. The Commonwealth would agree to unsupervised probation for a period of 2 years. Your 12-month sentence would be probated on the condition you not have any violations of the law, new arrests, you remain drug and alcohol free, but you would not be reporting to a officer. Do you understand all that?
Yes, sir.
Is that what you thought you were agreeing to?
Yes, sir.
Do you believe I added anything into the agreement that you didn't agree to when you came into this hearing?
No, sir.
All right. Ms. Hawkins, are you acknowledging to me that on July the 19th, 2019 in Barron County, you unlawfully used or possessed with the intent to use drug paraphernalia, and you knowingly and unlawfully possessed tramadol, which is a Schedule 4 controlled substance?
Yes, sir.
All right. Ms. Hawkins, I will accept your plea of guilty today. And Mr. Bell, are you still with us?
Yes, sir.
If you're asking, since this is not a felony in particular, we'll go ahead and do the sentencing, if that's okay.
That's fine, Judge.
All right.
We'd waive the PSI and make a motion to go ahead with final sentencing.
Ms. Hawkins, I'm going to, as I mentioned, accept your plea to counts 2 and 3. I'm going to dismiss count 1 pursuant to the recommendation of the Commonwealth, which is the felony charge, possession, first degree, first offense. I'm going to sentence you in accordance with your agreement to 12 months, grant the probation request under the terms and conditions that I just got finished discussing with you. Okay. I'm going to probate your fine as well. You will have court costs. It's $165, and I'm going to give you 6 months to pay that. So that's payable to the clerk's office. And if you, Mr. Bell can, hook you up with an address or something if you want to mail that in, or you can call and take care of it over the phone, whatever you want to do. Okay.
Yes, sir.
All right. Do you have any questions?
No, sir.
Very good. Mr. Hawkins, are you ready?
Yes, sir.
All right. Can you raise your right hand?
Yes, sir.
Do you swear to tell me the truth, so help you God?
Yes, sir.
All right, thank you. Mr. Hawkins, I'm going to ask you, did you also sign this motion?
I did.
Yeah. I can't really tell whether you're seeing it or not. I guess you saw it, didn't you?
Yeah, he can.
Yeah.
All right. And there's a signature page right there.
Yes, sir.
Okay. Similarly, the Commonwealth made an offer, and it's on this document here, and there's a signature page there. Did you sign that?
Yes, sir.
All right. Did you understand both of those things before you signed them?
Yes, sir.
Are you satisfied that you have had all the time you need to think about how you want to proceed?
Yes.
All right. Mr. Hawkins, do you understand that you too are waiving the right not to incriminate yourself, the right to a jury trial, the right to where the burden of proof's on the Commonwealth, the right to confront and cross-examine witnesses and put evidence on in your own defense, and the right to appeal?
Yes, sir.
All right, Mr. Hawkins, again, the Commonwealth is agreeing to make the following recommendations. Count 1, possession, first degree, first offense. On a plea of guilty to the remaining 2 counts, the Commonwealth agrees to a dismissal of that charge. Count 2, drug paraphernalia, 12 months. Count 3, possession, third degree, 12 months. Both of those are misdemeanors. The Commonwealth agrees to that 12-month sentence being probated for a period of 2 years, the same as the one to Ms. Hawkins. with the possibility of a fine up to $500 in court costs. Is that what you understand the recommendation of the Commonwealth to be?
Yes, sir.
All right, Mr. Hawkins, are you also acknowledging to me that on or about July 19th, 2019 in Barron County, you knowingly and unlawfully possessed or used drug paraphernalia and possessed a Schedule 4 controlled substance, tramadol?
Yes, sir.
All right, Mr. Hawkins will accept your guilty plea and go ahead with sentencing unless anybody objects. Your count
No
one,
objection.
okay, count one, possession, first degree, first offense, a Class D felony, dismissed. Count two and count three, I'll accept your plea. Pursuant to the recommendation of the Commonwealth, I will sentence you to 12 months, grant your request for probation for 2 years on the condition that you remain drug and alcohol free, no new arrests or violations of the law. Your probation is unsupervised. I'm going to probate your fine under the same conditions. You'll have court costs of $165, which I will give you 6 months to pay. And I guess whenever Miss Hawkins figures out how she's going to go about that, y'all can both. Okay?
Yes, sir.
All right. Just,
And,
yeah, go ahead, Mr. Bell.
I just wanted to ask the court to entertain a motion and the Commonwealth. I know it would probably take everybody to agree upon this, but Ryan and Joni both got these charges, both here and over in Hodgensville at a very close period in time. I think they both completed rehab. I think they've both been on probation now, just a few months shy of 5 years already, which was supervised very extensively. And I didn't know if Mr. Richardson or the court would entertain a motion in allowing some of that 5 years to count toward the unsupervised probation that we've been waiting on in this case, due to the fact that part of this was Mr. Hawkins got very ill, almost passed away, is my understanding, for a long period of time. Of course, COVID's kept us from this plea. There's just been a lot of things that has slowed down the gears. That's nobody's fault. It's just a pandemic. But I just wanted to see if the court or Mr. Richardson would entertain that motion and shortening this period of time that we put them on probation due to the fact they've already been on it almost 5 years.
So in essence, what you're asking is would they agree to probate this sentence for shorter than 2 years?
That's right.
Yeah. Mr. Richardson, are you on there?
I am. The only reason why I would object to that, Judge, is because part of the reason I agreed to dismiss the felony possession charge was because they were in the middle of trying to complete a pretrial diversion for drugs in another county, and they were showing that they were making, actual effort in that. And I know Mr. Hawkins also had some medical issues as well. I don't want to, I think I've done enough at this point, and it is unsupervised. So I'd like to have something there to where if they don't live up to their end of the bargain, that I would file a motion. Like I said, it's unsupervised. So I don't think it should affect their life too much. I just want to make sure they're not committing any other drug crimes after I basically cut them a break.
Yeah. And Mr. Bell, the only thing I would say in addition to that, I guess, is that, if the Commonwealth, the Commonwealth has made an offer and your clients have accepted that. So I don't think I can deviate from it unless there would be an agreement.
I agree, Judge.
You all could come in, at some point in the future, I guess, if he felt, if you all could reach an agreement on it and shorten that, if they went another year without having any trouble or whatever, but that would be up to you all to discuss. Normally we do have some leeway to shorten probation, but that is after people have been on probation, and then, you can either shorten it or what I tend to do is make it unsupervised, which has already happened in this case. So I don't know that we would do anything in the future, but it's possible.
I understand, Judge. We felt compelled to ask, and we've asked, and we appreciate the opportunity.
Yeah, I understand. All right. So Mr. and Ms. Hawkins, unless you all have any questions, I am done and you all are going to be free to go. Okay.
Thank
Okay.
you.
Thank
All
you.
right. Good luck to you all.
Thank you.
Judge, do you want me to stay on here for Gander, or do y'all just want to call me or something if he does come on, or how do you want me to handle that?
Yeah, I mean, if you're going to be available, we'll just wait and see if they join in. I mean, sometimes people join in late or whatever.
Yes, sir. I'll be available. Y'all just let me know and have a
All
good
right.
day.
Thank you.
Thanks a lot.
All right. Miss Polston,
Yes, sir.
what do I have going on with you here? Is this an arraignment? Miss Polston, can you tell me your address?
1363 Kefauver Road, Millwood, Kentucky.
1363.
Kefauver, Kefauver.
Okay.
That's Millwood.
You already have that? All right. All right. Okay, ma'am, you're here today because a grand jury has charged you with the offenses of possession of a controlled substance, first degree, first offense, possession of drug paraphernalia, and failure to produce an insurance card. The first of those charges is what we call a Class D felony. The remaining charges are the paraphernalia is a misdemeanor. The insurance card charge is what we call a violation, which is a finable, fine only type of offense. Do you think that you are going to be asking me to appoint an attorney to represent you?
Yes, sir.
All right.
Judge, this one would be Josh's.
All right. You with us there, Josh?
Yes.
All right, very good. So, Ms. Polston, I'll go ahead and appoint counsel to represent you. And tell you real quick that you have the right to remain silent. You have the right to a jury trial where the Commonwealth would have to prove guilt beyond a reasonable doubt. You have the right to an attorney, and I'm taking care of that by appointing one for you here today. You have the right to confront and cross-examine witnesses that give evidence against you, as well as the right to put your own evidence on your own behalf. And you also have the right to appeal. Do you understand those rights?
Yes.
Do you understand what you are charged with, or do you want me to give you any more specifics as far as dates or anything like that?
I understand.
Okay, then I'm going to enter a plea of not guilty on your behalf here today, and we will set this for a pretrial conference. While I'm looking at possible dates there, why don't you give, or Mr. Spears, you ask her what information you need from her, or give her whatever information you need to give her, okay?
All right. Rachel, can you hear me?
Yes.
All right. You have something to write a number down with?
Yeah.
Okay. My number is 833-385-6055. Just give the office a call in a week or two, like later this week, and we'll set up an appointment, start working on your case, okay?
Okay. 833-6055.
833-385-6055.
385. Okay. All right.
Yeah.
Thank you. I appreciate it.
All right.
All right, Ms. Polston, we're going to we're going to put your pretrial conference on for the 29th day of March at 1:00. Just get in touch with Mr. Spears within the next, week or two so that you all can discuss what your options are and how you're going to proceed going forward. Okay? Do you have any
Okay.
questions?
No, sir.
All right. So give him a call and then we will talk to you in March. Okay?
All right. Thank you.
Thank you. All right, let's see. I think we can probably take care of the going through our jail docket at this point. Mr. Driver, are you on there? Are you ready to go with yours?
Yes, sir. I've got Brittany Paxton, 21 CR 16.
Gotcha. Ms. Paxson? Mr. Driver, I believe what this is going to be is yeah, there was a new indictment, so this is an arraignment, okay?
Yes, sir, Judge. We're going to waive a formal reading, and she's going to plead not guilty, and then I'm going to request a bail reduction.
Okay, do you know when her other case has got a pretrial?
Yes, sir. The other case is set for a pretrial on February 22nd, 2021 at 1 p.m. And kind of the issue with that is I've attempted to obtain some prior medical records showing her treatment with a neurologist, and I've been unable to obtain those. And so I'm going to I attempted to call her last week, and she attempted to call me, and we were never able to discuss that. So I'm going to have to, talk with her about it to determine who actually was her neurologist and where she treated, because, I haven't obtained those records yet. And that was kind of the purpose of the February 22nd, that being on the docket for that day.
Sure. Do you want me to go ahead and reschedule that, or do you want to just see if the February 22nd bears any fruit when we get here?
No, I think we probably need to go ahead and reschedule it. That's why I brought it up, because we got those records in, but if I get it from another provider, I just, if I have to go to 2 or 3 different providers to try to obtain the records, it just could take longer.
Yeah, I understand. Well, let's do this. In this case, you are entering your appearance for her and waiving a formal arraignment. We'll talk about the bond in just a minute. But for now, we're going to enter a plea of not guilty and set this pretrial conference. What do you want, like an additional 3 or 4 weeks or what?
Yes, sir. Probably an additional 4 weeks, just to be safe, because, we went down kind of one dead road. So I need to really get with her, determine all potential medical providers.
So March 22, will that work?
Let's see, Judge, give me 1 second. Yes, sir, that will work.
All right. And then in her 20 CR, whatever the number is, 338, we'll reschedule that one as well to March 22nd.
Yes, sir.
All right. And then you had a motion.
Yes, sir. I would move that her bail be basically changed to an approved surety. She was out, and there was another charge, which she's denying she committed, but then her bond was basically increased, and she's been in jail since August. And right now it's set at 25,000, and she doesn't have any way to even make 10% of that. And I would ask that her dad be Leonard Blessing be appointed as an approved surety. In the alternative, maybe we could ask for a bond reduction down to 10,000, and maybe she can make the 10% of that.
Understand. Let's see. Is this Mr.?
It's my case, Your Honor.
Okay. Do you want to respond to that motion?
Yes, Your Honor. As far as, I guess it would be the same position we've had in the other cases when they've made a request for a bond reduction. In that case, I can't remember the sequence of which came first, case came first, but she was charged with a similar offense, was out on bond, and then picked up the very same offense in this case. So she has a now pending 2 Class B felonies. We think the bond is appropriate, considering her past history in these cases and Commonwealth does have concern if she's let out on bond, she might, pick up a third case and ask that the court keep the bond the same.
All right. Well, the same, or the concerns that you have are essentially the same concerns that I have.
Judge, may I throw in a third alternative?
Yes.
House arrest. So I would move that as a third alternative, she could be permitted to have house arrest, so she can get out of jail. So that would be a third alternative to her current bond.
Yeah, I understand. Mr. Gardner, same position, I assume.
Yes, Your Honor.
Yeah. Let me tell you, at this point, Mr. Driver, kind of as Mr. Gardner said, the big issue that I have is that these are two very, very similar. I mean, maybe the details aren't that similar, but the charges are certainly, from a macro standpoint, look like they're very similar incidences. And it causes me to be concerned when somebody has when somebody's out on bond for a Class B felony and then get arrested for basically the same type of offense again. At this point, I think the bond is fair where it is. I understand that it's a very large bond, and it's going to take a lot to make that. I don't think that it's inappropriate to say that we can look at it again if nothing changes when we come back in a month. And I'll have a better picture of what you all are trying to do, and if you're able to get these records, or it may be that you need her help to get them, or there may be some other factors that are brought to bear on it. But right now, I think that everything is probably adequate where it is.
Okay, thank you, Judge.
Okay, so I will see you all in this case on March 22nd. That'll be on the 1 o'clock docket. Okay.
Yes, sir. Thank you, Judge.
All right. Thank you. Michael Bixler. If you all want me to call anything out of order, just let me know. I'm going alphabetical here. You're telling me that he knows about the hearing that he refuses to get on? We can fix that by putting him back in custody, I guess. All right. Mr. Bixler, I believe that your case is on. You have two cases. They are on for arraignment. My first question to you would therefore be, are you expecting that you will be asking me to appoint you an attorney, or do you have an attorney? Where do we stand on that?
Yes, sir. I'll be needing an attorney.
Okay. Mr. Bixler, can you tell me your address?
300 St. Paul Avenue, Bowling Green, Kentucky, 42101.
All right. Very good. Thank you. Mr. Berry, I'm going to appoint your office to represent Mr. Bixler on these two cases.
Okay, Judge.
They are both 20 CR 314 is trafficking in a controlled substance, first degree, greater than or equal to 2 grams. That is a Class C felony. And FO first. 20 CR 349 are the same two charges.
That will be Ms. Myers, Judge.
All right. Ms. Myers, do you want me to formally arraign Mr. Bixler, or do you all waive a formal explanation of charges and rights?
Your Honor, we'll waive formal reading of the indictment and enter a plea of not guilty at this time. Like to reserve any pretrial motions, pre-arraignment motions at this time as well.
Yes, ma'am. That's fair. Mr. Bixler, Just so you understand what we're doing here, I'm going to appoint counsel for you. And on your behalf, we are entering a plea of not guilty. I'm going to set a pretrial conference. I think under the circumstances, I can set that pretrial conference probably for March the 22nd. That's about 6 weeks from now. On the afternoon docket. In this case, the bond on each indictment was set at 5,000 cash. Each case involves a PFO and a Class C felony. You know, the essential reason that it was set at a cash bond is because Mr. Bixler's criminal history is significant, with prior convictions for trafficking in a controlled substance as well as manufacturing methamphetamine. And I felt like and continue to feel like a $5,000 bond is not unreasonable under the circumstances. However, if there is a motion, if there's going to be a motion to amend that bond, and you know, you all want to file that, I will certainly give you the opportunity to put on any evidence that you want to about that. But I mean, as far as an arraignment discussion is concerned, you know, I looked at his criminal history when I set the bond, and I think that it's not unreasonable. Okay, I think that there's a pronounced risk of reoffending, if nothing else. All right, so I'm going to leave that where it is for now. We will have a pretrial conference 22 March at 1 o'clock. Okay.
Thank you, Your Honor.
Thank you. Okay. Amber Carver.
How you doing today?
Hello, Miss Carver.
Judge, that's my case. Amber's, I think we've got two things on this morning. One's a motion to revoke bond. The other's a pretrial.
Yes, sir.
Oh, go ahead.
I think the motion is based on a couple of misdemeanor arrests for PI. I don't know. I don't aim to be putting on the Commonwealth's case here, so I'll turn that over to, I think, Mr. Richard. No, it's Mr. Gardner's case. I'm sorry. But as far as the pretrial conference, we don't have an agreement yet. I've talked quite a bit with Amber on this case and then looked at the discovery pretty extensively. And I just have a problem with her pleading guilty on an arson on this, but I know the Commonwealth feels different about it. But anyway, that's something that we may have to solve in other ways than plea agreements. I don't know. But as far as her bond motion, she's been in quite a while now. I don't know exactly when she was picked up on this. She's been in jail quite a bit on it. There is, we would ask the court to consider releasing her back on her bond because of, I think, I was all kind of wondering if she was put in jail just to kind of get her a place to stay for a while, because she was homeless at the time. I believe she was picked up. I would like for the court to give her an opportunity to get back out and see if she can get into some type of shelter or something along those lines if she doesn't have a place to stay otherwise.
I actually got a bed in a rehab as of Thursday last week. I'm not sure why I haven't been able to go yet. It may just be a transportation issue, or I wasn't sure if possibly you were still holding me.
Well,
Honor,
yeah,
at the last time we were in court, the Commonwealth said it would agree to a modification of the bond if, found a residential drug treatment place. And she says that that's been done. I'll stick by my word on that.
yeah, that's the first time hearing that there was any, I think what you said the last time was that you were trying to get in someplace, but I haven't heard any details, I don't think.
It's called the Recovery House. I've got their phone number, not with me, but I have their phone number. I
Where
talked
is
to them
that?
on Thursday. I forgot to ask. I was so excited to go.
Are they going to come get you?
They were saying they were trying to arrange transportation with the social worker through the Department of Public Defense.
Bethany did send us an email this morning. She has been accepted to Recovery Works, but they just have not given us a bed date yet.
All right.
They evaluate first of every week, so we're waiting on that.
Yeah, listen, everybody's saying a lot of things that are largely correct here. Mr. Berry is right that, the big issue was Ms. Carver was out on bond. In this case, I think she got picked up twice in the district court. And I didn't do a hold on her, either time because they were Class B misdemeanors. And, I was trying to kind of give her a wide berth, but I think the third time, there's something going on that, I understand that this is probably not what the textbook says about looking at bond, but you're not doing anybody any favors if you keep tossing a homeless person out on the street that's having problems, and it's, 20 degrees and they keep getting rearrested and racking up new charges. At some point you kind of have to step in and say, hey, listen, let's try to approach this systematically. And I'm certainly agreeable if I get the information from Bethany or whatever the case may be. I will be agreeable to trying to get her released to go to treatment, but it sounds like she's going to have to get a ride to get there.
Well, when I talked to them on Wednesday, they were talking about arranging a ride for me the following day. So
yeah, well, so what Mr. Gardner, or what Denise is telling us is that they should get some information with some specifics like bed dates and times and locations and all that. And when I find that out, I will do an order and arrange for you to get there.
Okay.
Okay. Miss Carver, there's a couple of things that you'll need to know. Number one, I'm going to give you another pretrial date and you'll be responsible for making yourself available for that pretrial, which means if you're at the rehab and you have access to a phone or a computer or something like that, we can do it that way. Or you can notify your attorney that you're unavailable so that we can move it. We can't just start looking at all the rehabs for you. So you'll have to kind of take some responsibility to let Mr. Berry know where you are. Okay.
Okay.
All right. The other thing is that when you do get out, you'll still be on bond. So, this doesn't resolve your case or anything. This just is a way to help you, be someplace where something positive can be happening rather than just sitting in jail. Okay.
That sounds great.
All right. So let's move the pretrial conference to the 29th of March. And like I said, that'll be on the 1 o'clock docket. Okay. And like I said, you need to make sure that you're staying in contact with your attorney's office so that we know what's happening when that date rolls around. Okay.
Okay. Thank you.
Now, so you'll be there until I hear what the details are, and then I'll do an order that gets you out. Okay.
Okay.
All right.
All right. Thank you.
Jimmy Chapman.
He's on for sentencing in two different cases, Judge.
Yes, sir. Mr. Chapman, your cases are ready for final sentencing, assuming that you have had the opportunity to review your pre-sentence investigation in
And-
these cases. Have you had that chance?
Yeah, and a lot of things are wrong in it too.
Okay. Mr. Barry, is this one yours?
It is,
All right.
both of them.
Since Mr. Chapman has had the chance to look at his PSI, subject to whatever corrections he's got about the PSI, which we'll get into in a minute, are you ready to go forward with sentencing, Mr. Barry?
I am, Judge, if Jamie is.
Yeah, I was gonna ask, could I get a 30 days out, because I turned myself in, get a house arrest for 30, because my kid's got COVID, he's 5 years old, and I ain't run or nothing, you know what I mean? I found out I had a warrant on me and I turned myself straight in.
I guess we can address that, Mr. Richardson, before we do anything else.
Yeah, see, I got a paper in the mail saying that they put it off till April, then I heard I had a warrant, so I called the law to come pick me up.
Yeah, I mean, you got a warrant because we got a report that you were still on bond, and we got a report that you had violated your bond by having a dirty drug test.
Yes, Your Honor. I mean,
That explains, you are correct about everything that you've said. We were putting your sentencing off because you were out of custody and we weren't able to get there for a while. It was tough for us well, it still is tough to get some of these sentencings taken care of and other things taken care of when people aren't in custody. So, you were out for a while because of that, but that was while, as long as I thought everything was going okay with your bond.
yeah, but I messed up,
Yeah.
But I just say if I can get 30 days out with my kids, man, my 5-year-old's got COVID.
Mr. Richardson, that's his request. What do you have to say?
I'm going to oppose it, Judge. I understand him making the request. I don't blame him for asking, but, he back in August had to file a motion to revoke his bond because he wasn't showing up to his drug test. And when he was finally tested, he tested positive. He pled guilty, and I withdrew my motion and was okay with him being out. And then he picked up another relatively minor drug charge, but it's still an indication that he didn't learn the first time. So I would oppose him being released and has to go forward with sentencing.
Well, yeah, let me tell you how I feel about it. And this is not, it is what it is, but your sentencing was set in, I think, October. And the recommendation of the Commonwealth is time to serve. You've really had what amounts to November, December, and January, where if you'd gotten sentenced as scheduled, you'd have probably, in all likelihood, been in custody that whole time. So you've kind of gotten 3 free months out of this deal. You didn't do anything wrong to get it. Don't get me wrong. I'm not begrudging you on that or accusing you of anything. But I feel like that's, if not for the things that were outside of your control and mine and everybody else's, you'd have been in custody when already by now anyway. So I don't think that's an appropriate reason for me to not proceed with your sentencing. I just think it's time for us to move on and get the.
I talked to Julie and them, and they said that they didn't see why that, and I couldn't go back on it, but I understand.
Yeah, well, yeah, they're what they're saying, I suppose, is that they'd be willing to keep supervising you, but they're not making legal decisions. So, it is what it is.
I didn't know. I was gonna see if I can get on house arrest or something. I didn't know 30 days just to make sure.
Tell me about your corrections that you have on your PSI.
Like the time, like it says, I got 120 days, and I was on ankle monitor way longer than that. I was on house arrest for like 10, 11 months, and they only give me like 120 days. My address is wrong. My wife's name's wrong. Everything's wrong.
Yeah.
My dad's death date's wrong. Everything is.
Listen, all you need to do is tell me what the right answer. I know you don't know how many days you've got, and I agree with you. You were on an ankle monitor for a long time. Probation and parole doesn't really have any way to know that, but we can provide that information to them about how long you were on house arrest. And, you know, we can look through the file and get those dates and provide that to them.
At least down it a year.
Yeah. They'll give you credit for that. That's a legitimate thing for you to bring up, and you're entitled to way more than 120 days worth of credit. I agree with you. I don't have the exact number, but that won't be any problem to figure out. Okay.
Okay.
All right. Tell me what the correct address should be.
On my mom's, it's 209 Sunset Avenue.
All right. That's Martha,
Martha, yeah.
209 Sunset Avenue.
Yes, sir.
All right. What else we got?
And my dad's death date is 2003, not 2012.
Okay.
And I got 5 kids, not 2 kids.
I would say that they just grabbed a bunch of you probably had 2 kids back in 2012, the first time we ever did a PSI on you, and they just grabbed up a bunch of that information and so that they didn't have to ask you, right?
Yes, sir.
You think?
Yeah, I mean, I went out there probation and parole when I was out, and they said, okay, we'll call you, and they never called me when I went out there for that PSI to tell them about everything.
Yeah. And listen, I don't doubt what you're telling me. I mean, those things are happening. You know, I mean, they've had some COVID issues out there and had to shut their office down just kind of on the cuff, you know, not knowing, just finding out that they have to shut it. You know, there's a lot of things happening. So I don't have any problem asking Officer Bragg, he's our PMP representative here, to make those corrections. You have 5 children and your father passed away, 2003? 3?
Yeah.
Yeah.
Yes, sir.
Yeah. And Martha lives on Sunset at 20.
And my wife lives on 248C Lauderdale Drive.
248C Lauderdale Drive.
Apartment C, yeah.
All right. Good enough. Do you have anything else that you want to correct?
No, sir.
Okay. Mr. Berry, anything that you all want to say as a, prior to imposing sentence?
No, Judge, not at this time, other than we request the court to follow the plea agreements.
Okay. Anything that Mr. Richardson, on behalf of the Commonwealth, that you want to say?
I don't have anything to add, Judge.
Okay. You jump in here and correct me if I get this wrong, but in the 18 CR 561 case,
Right.
the recommendation on the guilty plea was a 3-year recommendation. In the 18 CR 639 case, the recommendation of the Commonwealth was an 8-year recommendation. The 2 sentences were recommended to run concurrently with one another. The Commonwealth opposes probation. Is that the upshot?
Yes, sir, that's correct.
All right. And Mr. Chapman, again, let me just say that under the circumstances of the case, you know, I understand why you're requesting what you're requesting, but again, we were supposed to be sentencing you way back in like September, October, back in that area, and we would have been doing the exact same thing. You know, all the same arguments would have been being made, and you know, at the end of the day, what I'm going to do is sentence you in accordance with the agreement that you made, which is 3 years on the possession and 8 on the burglary case concurrent, for a total of 8. I'm waiving your fines and your court costs. I will have your house arrest time recalculated, or not recalculated. It wasn't calculated in the first place, but we'll get it calculated and provide that information to probation and parole to be sure that you get all your pre-sentence custody credit that you're entitled to, in addition to the 120 some odd days that they gave you. Okay?
Okay.
All right. Good luck, sir.
Thank you.
Betty Johnson. All right, this is a similar scenario where Ms. Johnson has had a sentencing that was scheduled way back in October. We were unable to do it as scheduled, so here we are. In the meantime, she's picked up a new, I believe, felony charge, and that's why I thought it would be appropriate to go ahead and get this sentencing taken care of. I don't remember if this case involves, which attorney this case involves.
It's mine.
Mr. Spears, yeah.
Yes.
It also looks like I've been handed, I didn't know I had this until just now. Does she have a plea on that F case that you all want me to go ahead and do?
Yes.
All right. Would it be appropriate from your all standpoint if we try to do that first and then talk about sentencing in both of them?
That's fine.
All right. Ms. Johnson, can you hear me?
Sir.
All right. Can you raise your right hand?
Yes, sir.
Do you swear to tell me the truth, so help you God?
Yes, sir.
Yes?
Yes.
Okay, thank you. Ms. Johnson, I'm going to show you what I have in my hands here and ask you some questions about these documents. Mr. Spears, I have a question. Is there a motion to enter a guilty plea and I just don't see it?
Yes, it was e-filed this morning.
Okay. Can you pull that up and see if it's in there? It would be in 21F 058. All right. Are you able to print that? Okay. Ms. Johnson, do you understand that nobody can make you plead guilty, and if you plead guilty, that has to be a decision that you make voluntarily?
Yes, sir.
All right. You understand that you have the right to remain silent. You have the right, in other words, not to incriminate yourself. You have the right to a jury trial where the Commonwealth would have to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine witnesses and the right to put evidence on in your own defense. You also have the right to appeal. Do you understand those rights?
Yes, sir.
Do you understand that if you plead guilty, you are waiving those rights?
Yes, sir.
All right. Do you feel like your judgment is impaired today for any reason?
No, sir.
Are you under the influence of any substance or combination of substances?
No, sir.
All right. Ms. Johnson, is this your signature?
Yes, sir.
All right. And do you recognize this document as being the motion to enter a guilty plea that you signed?
Yes, sir.
All right. Did you understand it when you signed it?
Yes, sir.
Thank you. The Commonwealth has made an offer and it's on this document. Does that look familiar to you?
Yes, sir.
All right. And there is a signature page on the back. Does that have
Yes,
your signature? Okay. Did you understand that document when you signed it?
Yes, sir.
Are you satisfied that you've had all the time you need to decide how to proceed and talk to your attorney?
Yes, sir.
Yes?
Yes, sir.
Yeah, I'm sorry. I was shuffling papers and it got loud. It's not your fault. Ms. Johnson, in this case, the Commonwealth is making the following recommendations. Count 1, possession of a controlled substance, first degree, second offense, a Class D felony. On a guilty plea, the Commonwealth recommends 2 years. On count 2, possession third degree, that's a misdemeanor. Commonwealth recommends 12 months. Drug paraphernalia is count 3, that's a misdemeanor. The Commonwealth recommends 12 months. Count 4 is prescription not in the original container. Commonwealth recommends 90 days. Count 5, marijuana possession. Commonwealth recommends 45 days. The upshot there is that all those sentences are concurrent or at the same time for a total of 2 years. The Commonwealth agrees to a supervised period of probation lasting 3 years for you to get an assessment for substance abuse as part of that probation and for you to comply with the recommendations, if any, that come from that assessment. Do you understand?
Yes, sir.
All right. 2 more things. There would be a 15-day alternative sentence and which would go back to your arrest date. And the sentence in this case would be consecutive to the sentence in the case that we're getting ready to talk about in just a minute where you've already pled guilty. So if something happens and you got revoked as to probation in both cases, you would have to serve them back to back instead of at the same time. Do you understand that?
Yes, sir.
Okay. Other than what I have just talked to you, has anybody threatened you or promised you to try to get you to plead guilty?
No, sir.
All right. Ms. Johnson, are you acknowledging to me that on February 1st, 2021, in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine, having a prior conviction for possession of a controlled substance?
Yes, sir.
Are you also acknowledging to me that at that same time and place, you were in possession of a Schedule 4 or 5 controlled substance, which was gabapentin, as well as drug paraphernalia and marijuana?
Yes, sir.
And finally, are you acknowledging to me, ma'am, that you were in possession of a prescription controlled substance that was not in the container in which it was dispensed?
Yes, sir.
Right, okay. So that is a plea of guilty to each of those charges. I'm going to accept your plea. And now let's turn our attention to 20 CR 096. In that case, you had a PSI prepared some 3 or 4 months ago. Have you had the chance to look that over?
Yes, sir.
All right. Are there any questions or corrections or modifications that you feel like need to be made to that?
No, sir.
All right. Mr. Spears, any reason that you are aware of not to proceed with sentencing today?
No, Your Honor, we just asked that the sentence be part of the agreement.
All right. Mr. Richardson, the sentence in that case, the recommended sentence was a 2-year sentence and plus possible fine and costs, supervised probation, SSC assessment. Is that still the position of the Commonwealth? Subject to the other case where she's got a 15-day alternative sentence.
Judge, is this on Betty Johnson?
Yes.
Is my name on it? I'm sorry. I thought it was John's case because that's
It is
what
my case, yeah.
It might
is.
be. I thought that you were the one that did this. I apologize. My bad. Mr. Gardner, is that still the position of the Commonwealth?
It is, Your Honor, yes.
Okay. Ms. Johnson, in 20 CR 096, you entered your plea prior to today's date. I am going to sentence you today to 2 years. Fines and costs are waived. I'm going to grant your request for probation. We'll probate that sentence for a period of 3 years on the condition that you cooperate with probation and parole, follow the rules that they go over with you, and you get that substance abuse assessment that we were talking about. If any treatment gets recommended, you have to do that as part of your probation. In the case that you just entered your guilty plea on, I'm going to do the same thing with the following exception, and that is that prior to beginning your probation, you will have an alternative sentence per the agreement that you reached with the Commonwealth of 15 days. That goes back to your arrest date, which was about a week ago. So after you have served those 15 days, which is another week or so, then you will be released to report to probation and parole. Do you understand that?
Yes, sir.
All right. Mr. Officer Bragg,
Yes, sir.
this young lady is going to be probated on those 2 cases. She's got an alternative sentence of 15 days and she's on about day 8 or 9 of that right now. So can you tell me what your instructions are?
The day she gets out, she'll just need to come to the office. If it's on a weekend, she'll need to come on Monday. But if I could get a phone number or address for her, presumptive her release from jail. So does she have one?
Yes, sir.
Okay, start with the phone number, please.
270-404-4865.
And what's your address?
2570 Carden, Carden Road, Glasgow, Kentucky, 42141.
Okay.
All right, she should be released on a week from today, on Monday, the 15th.
Okay. Yeah, sure. I'm just gonna put down that she's gonna report on that day and they'll be expecting her.
All right. Ms. Brown, do you know where the probation and parole office is? Ms. Johnson, I'm sorry.
Yes, sir, I know.
Do you know where the probation office is? Okay. So on the day that you get out, you need to be there by 8:30 in the morning, okay?
Okay,
You'll get out before that, so that'll be all right.
all right.
Okay, do you have any questions?
No, sir.
All right, good luck, ma'am.
Thank you.
Matthew Runyon. All right, this is on for a motion to revoke probation filed by the Commonwealth and a supplemental motion filed to address a new arrest that occurred, it looks like in October or thereabout, or September. Ms. Gardner, I believe this is your case. I think. Is this your case? Her microphone's not working.
Can you hear me now?
I can hear you. You're going to be asking me to set this for a hearing, correct?
Yes.
All right. We'll set this for our next revocation docket, which is 23rd February.
That'll be my case, Judge.
All right, I was getting ready to ask Mr. Runyon there, Mr. Berry, because he had Mr. Garrett when he entered his plea, but I bet you he's going to need counsel, so appointed. So I'm going to go ahead and note here that I'm appointing.
Okay.
Okay?
All right.
All right. Anybody have any questions? All right. Thank you. See you on the 23rd.
Thank you.
All right. This is for you. Miss, well, that's the wrong person. Mark Stilts.
That's my motion, Judge.
Okay. This is the Commonwealth's motion to void pretrial diversion. The pretrial diversion was subject to reporting to U-Turn. The motion is based upon the report from U-Turn that there have been looks like essentially
There are 4 no-shows and then 1 recent positive back in January.
multiple issues. Yeah. All right.
Your Honor.
Yeah, go ahead.
Sorry to interrupt, but I think this is Mr. Stilt's first time appearing on a motion to void this pretrial diversion. He was being supervised by U-Turn, and I would like to make an offer instead of scheduling a hearing, if he would be interested in hearing what I have to say.
Yes, ma'am.
Okay, I think that he needs more supervision, increased supervision, and I think that we probably need to switch it over to probation and parole. And I'd be willing to do a 10-day sanction starting today, and then have his supervision transferred, and then an SSC assessment. Or if DPA wants to have Bethany assess him.
Mr. Stilts, do you understand what Ms. Gardner is suggesting?
No, sir.
All right.
Not all of
it. Yeah, let me tell you. What she is suggesting is that instead of voiding your diversion, which would if we did that, would make you a, a convicted felon and subject you to being sentenced, to serve.
Yes, sir.
That you would do a period of 10 days in jail, followed by going to probation and parole instead of U-turn. So when you'd be supervised by the probation office instead of U-turn, but you'd stay on pretrial diversion. And if you didn't have any more problems, it would end just like it was supposed to end whenever it is. The only other component would be that we'd get a substance abuse assessment to see whether or not they need to recommend you to go to any kind of treatment or, outpatient counseling or whatever it might be.
Yes, sir. About is there any way I've never had a charge in my life. I've always worked, never been in any trouble. I've been in here since Saturday night. Is there any way I could go on and get out?
Well,
that'd be agreeable with Mrs. Gardner.
Your Honor, I'd be willing to do credit for time served, so you'd have some more additional days.
So instead of 10 days starting today, it'd be 10 days starting last Saturday. So we'd basically be a week.
Correct.
The offer would be that you would do a 10-day sanction, but it would start on your arrest date. So you'd get credit for those days, which would basically mean you'd be getting out next week instead of, or 10 days from Saturday rather than 10 days from today. But that's what the recommendation is. Let me just give you a little bit of something that you don't know because you don't do this all the time. If we had a hearing, it would be in 2 weeks and you'd probably be in custody till then anyway. So you'd just automatically get 2 weeks in jail, just having to wait for your hearing.
Yes, sir.
So this would cut that in half.
Okay. So basically how many more days do I have to be in here?
Well, let's see.
I got no idea.
Saturday was the 6th, right?
Yes, sir.
Tuesday, the 16th.
Next Monday.
Next Monday.
Yes, sir.
There's no way she was willing to reconsider on this at all.
Well, I'll let her speak for herself, but I think she's probably done all the reconsidering she wants to.
Yeah, I think just in light of the fact that there are multiple no-shows for drug testing, therefore July, September, October, and December, and then we have a positive in January, I think that my offer is fair and I'm sticking with it.
Okay, ma'am. Yes, ma'am.
Judge, we would be glad to have Bethany do the assessment this week, if that's all right.
That would be fine with me.
Okay.
I have no objection.
Are we appointed on Mr. Stilt's, Judge?
He was a rocket docket.
Yeah, Greg, it was a
okay.
rocket. Yeah, it was a rocket docket case, but you all presided over it when it happened.
Okay.
It was about a year ago, something in that ballpark. Mr. Stilts, is that a go or?
Yes, sir. If that's the best, I'd like to get out.
I understand.
I've got pets I worry about.
I understand. Well, listen, if you do this and you kind of knuckle down a little bit and don't have the same problems that you had that put you in there in the first place, this will be the last you'll hear of me.
Yes, sir.
Okay?
Yes, sir.
Here's what we'll do. Officer Bragg is on here. I think what he's going to tell you is that you will be reporting to probation and parole the day you get out, which is going to be next Monday. So they're going to want you to report by 8:30 a.m. that day, which you'll get out, or you'll get out earlier than that.
I don't have no transportation, sir.
Okay.
Can they give me a little slack on getting there?
Well, what are you going?
As I could.
What are you going to do about getting a ride home from jail?
Shoot, I don't know. I ain't got a phone card. I ain't got no money, and nobody bring me no money. I don't know who I can call. I guess I was planning on taking off walking when I got out of here.
How far do you got to walk?
Well, I live in Metcalfe County.
Oh, Lord.
If he walks to our office, we'll let him use the phone and try and find some transportation. We're not that far from the jail. compared to Metcalfe County.
Yeah, that's on Reynolds Road, right?
Yes, sir.
Yeah.
Yes, sir. So here's what, Mr. Bragg or Officer Bragg, is that reporting that morning? That's what you want him to do?
Yeah, and can I have a phone number for him in case something were to happen and he don't show up, or do you have a phone number?
A home phone?
Yeah,
I have a home phone. That's all I got.
that's fine.
It's 270-432-4400.
Okay. All right, yeah, then just report Monday morning at 8:30.
What time do I get out here?
You'll probably get out about or 6 or 6:30.
I hope I can make it by then.
Oh,
Okay, far.
if you don't get out there, if it takes you more than 2 hours to walk there, you've taken a wrong turn.
Okay.
It's just about a mile.
Yeah, okay.
Okay.
Okay, sir.
Maybe a little more. All right. Mr. Stilts, let's, like I said, let's kind of straighten this thing out, and you'll be out. You won't have to be back in court for anything. Okay.
Okay, sir.
All right. Good luck, sir.
Thank you, sir.
Emily Terry.
That's also my case, Judge. It's on for an arraignment, and I also filed a motion to revoke bond.
Yes, ma'am. Ms. Terry, do I need to appoint counsel for you?
Yes.
All right, Mr. Berry, I'll appoint your all's office on this. I think you all were involved in this case when it was at the district court level. You've got a lot of I don't know if you got all these co-defendants, but you got a lot of them. Colton Keller, Brandon Bradshaw, and Timothy Adams Jr.
Bradshaw has Johnny.
Okay, yeah.
Okay. We have Mr. Keller, I believe.
Yeah.
I didn't hear who was the last one you named?
Timothy Adams Jr.
Okay, he's ours also. So we'll probably send Miss Terry outside the office.
Okay. Can I go ahead and arraign her?
Sure, we can do the arraignment.
Okay. So Ms. Terry, we'll make sure that you have an attorney, okay? For the time being, Mr. Berry, you're going to stand in just for the purposes of this arraignment. Mr. Berry, do you wish to have her formally arraigned?
No, we'd waive formal arraignment, enter not guilty plea to all the charges.
Okay. Do you want her to give you a phone number, or what arrangements do you want to make for getting in touch with her or having her get in touch with you?
What is this bond motion going to be set at the next hearing date, or
can I tell you what, in this case, she was being supervised by the U-turn program, and Miss Atkins called me about her and said that I think she said that she and Miss Terry had talked about maybe getting into a rehab place real quick. I know that Julie wants to get her in one real quick. I don't know if that was a agreement that they had or what, but I would be willing to allow, to try to make that happen if that's something that everybody else was agreeable to. And it may take a minute to get, for Julie to get her a bed date, but I think she's already kind of looking into it.
If she's, Miss Terry, you have a phone number?
Yes, it's 270-308-9023.
Okay. We'll pass that on to whatever attorney's gonna pick up her case, Judge, so they've got contact information for her.
What I was going to suggest is that we put the Commonwealth's motion on for Monday, and we'll get Miss Atkins. We can go ahead and notify her, and if Mr. or Miss Terry, if you're agreeable to her trying to find you a short-term rehab place, I'll go ahead and get her to start doing that. If you're not agreeable to that, then we'll just have a hearing about your, to see whether you're going to get your bond back or not.
That's fine with the rehab. I'd rather see if I can get a bed date.
Okay. Did you all, was I wrong that you all had talked about that or was I remembering that wrong?
Yeah, we talked about it. We
Okay.
agreed on that.
All right, all right. So that's what we'll do then. We'll notify Julie and get her, tell her that Miss Terry's interested in that. And then maybe when Monday rolls around, we'll have a plan. Okay?
All right.
All right. I'm going to note here that you've entered a not guilty plea. Motion to, let's go ahead and set a pretrial conference for March 29th. But we'll put the Commonwealth's motion on for Monday, the 15th of February
Okay, Judge.
at 10 o'clock. All right, Miss Terry, we'll see you, okay?
All right. Thank you.
Dalton Wyatt,
Line Judge, he's gotten arraignment in a new case, but I also have a pending motion to revoke probation, 2 other felony cases. I was gonna ask for a hearing.
all right. Mr. Wyatt, do I need to appoint an attorney for you or do you have a different plan in mind?
You can probably appoint me one, but I was gonna say if maybe you couldn't maybe send me to a long-term treatment rehab.
Okay, well, let's get need to keep our cart behind our horse here. All right, here's the deal. Mr. Berry, Mr. Wyatt's got a new possession, first degree, second offense, and then paraphernalia and drug paraphernalia. That's 20 CR 205. I'm going to appoint the DPA and set that or arraign him today.
Okay.
So, Mr. Wyatt, you all need me to formally explain your charges and your rights, or do you want to waive
Nope. We'd waive formal arraignment and enter not guilty plea to all charges.
Okay. Mr. Berry, in the other 2 cases, I'll need to appoint him an attorney for those 2. He's on probation in 16 CR 197, 17 CR 455. The Commonwealth's motion to revoke, we can put that on for February 23rd. And then, if you all want to talk about some resolution of that or treatment or whatever, that's up to you all.
Okay, Judge.
So hearing 223 at 1:30. All right, Mr. Wyatt, we'll see how that works out, okay?
Thank you, Judge.
All right. And we'll just move that pretrial to February 23rd also and keep it all together. Left one out, sorry. Nicholas Hodges. Let's see, Mr. Berry, are you with us?
I'm sorry, Judge, I'm getting phone calls and everything all at one time.
No, that's fine. You didn't know about this case because he's not on the docket. I don't know. I think when I saw him on here, I was trying to figure out too, but I think Jennifer told me that he got added on because there was a new arrest. Is that right? And over the weekend, I guess. Okay. He's got this 20 CR 79 still pending that he had a pretrial for. And because he was out of custody, it's gotten kicked down the road a few times. But now that he's now that he's in custody, I think let's at least have that pretrial. And if you want to do that next Monday, we can do it and, see where we are.
That's fine.
Okay. I know that you might not have made contact with him because I've got the letters that we've been sending to reschedule his court dates, and the address that he was at when all this started, all those letters are coming back. So he's probably got a new address.
No, it's a PO box. PO Box 2081. I've received a couple of them. I just don't check it every day. I check it about every 2 or 3 days.
Your Honor, Mr. Hodges was arrested on the 7th, I believe it was, and it's a new possession case, as well as I think some driving offenses as well. There's been a motion to revoke his bond prepared. It's in my inbox. I was going to file that today.
All right. Can we, do you have an objection to this? Can I put this on next Monday at either the 10 or the 1 docket? I don't care. And is that enough time, Mr. Berry, for you all to talk, or, do you want 2 weeks?
Probably 2 weeks, Your Honor.
Okay. That is 2/22.
Okay.
You want 1 o'clock or 10 o'clock? Do you care?
10 a.m. is fine.
All right. Yeah, we are. Yeah. I didn't know we got arrested.
Hey, Your Honor.
Yes.
I'm supposed to be going to Park Place. And waiting on the bed to get open. They said something about putting me in there. This was what's her name? Annie out of Life Skills in Bowling Green. She's trying to get me a bed open. I had told her I'd like to go back to treatment.
Okay. Well, right now we got this pending motion, so we need to see. I mean, if you get a bed date and somebody notifies us of that, we might be able to make that happen.
Well, it's kind of hard for me to do it in here, but.
Well, I understand.
I guess, Greg, if you don't care, man, get a hold of this lady in Life Skills of in Bowling Green. Her name is Annie.
Okay.
See about getting a hold of her or somebody over here. I got 3 meth cases here, so go ahead and get the rocket docket for this last case too. I don't want no consecutive. I'm just ready to get all this behind me.
You've got 2 pending. Is that what in district court or 1?
There's 3 over here. There's 3 cases over here now.
Yeah, but you've only been indicted on 1 of them, right?
We done a rocket docket on the second one, so we can go ahead and do another rocket docket on this third one.
So we've already done a rocket docket on 1 of them?
Yeah.
When did we do that?
That was shit.
I don't think we have, Judge. That case is still pending as far as I know.
Yeah.
Oh, he just did, I think we did an information, but he didn't enter a plea. Is that right?
Right.
Yeah.
Right.
Case needs to be put on with this one.
That's what I'm saying. Just go ahead and put them on.
Yeah, I got it now. I'm just telling my clerk because they only have 1 case brought up. He said, he's right. I believe that, I remember he just agreed by information to bring that other case up here, but they didn't enter a plea on it.
Nope.
Anyway, we're going to put you on the docket and we'll try to get everything, have all your cases here in one spot. Okay.
All right.
All right. See you.
All right, man.
Judge, all I'm showing is this 20 CR case that's pending in court net.
Well, and I may be remembering somebody different, but I remember us doing that on somebody's case because it was unusual, because usually there's a plea that goes along with it. And
we have we had the suppression hearing in this case.
Right.
that was about the last thing we did before the pandemic. And
All right, well, if we didn't, we didn't. Well, it'd be easy enough to figure out if he's got two. Anyway, all right. Matthew Stout,
Hey, Josh, can you cover these for a minute?
Yeah.
we did that for somebody. Man, I didn't. All right. All right, let's see. Mr. Gardner, I believe you filed this. This is a motion to revoke probation. It was filed back in November. We haven't ever had a hearing on it because he was out of custody. But now he's back in custody. Something new must have happened. So want to set this for a hearing?
yes, Your Honor.
Okay. All right, so that'll be 2/23. February 23. Do I need to appoint counsel? I guess I do, don't I, Mr. Stout?
I wouldn't worry about it. I mean, I'd go ahead and say revoke it and let it go. I mean, I don't see no way of getting out of it, so.
Well, that may be, but I want you to have the advice of an attorney before you agree to that, okay?
I was supposed to have Scott Basil on it, so that's all I know. But if I don't, I don't.
Well, I know he represented you at some point, but I mean, if nobody had, once you get your plea entered or whatever, that ends that.
Yeah, I know. Yeah, you point somebody if you want to. And like I said, it don't really matter. I don't see no way out of it. I just picked up the new charges, Friday night, so.
Okay. I'm going to appoint you counsel and we'll put your hearing on for February 23rd and we'll see what happens, okay?
All right, thank you.
All right, you bet. James Mercer.
Yes, Your Honor.
All right. This case is going to, I think the Commonwealth's probably going to end up filing a motion to revoke because I believe that we all got the same email.
Yes.
I do have Johnny Bell as a attorney now.
Well, is this, Arisa, are you going to be doing this one?
Yes.
All right. Will you get in touch with Johnny?
Do you want me to get in touch with him now and see if he can get on, or?
Well, I mean, not unless you plan on making an offer to resolve it today.
No.
You would want to have a hearing and then
I'll let him know.
I'm going to set it for a hearing on 2/23. That's the part I was just asking you to get in touch with him and let him know that we're setting it for a hearing and you can send your motion to him and,
Okay, I will.
all right.
All right.
All right. See you then.
All right, see you.
Miss Bonnie, you have anybody else on this morning docket?
No, that's all I've got, Judge.
All right. We shall see you in a little while.
See you in a little while.
Hey, Judge, can we call Brandon Coy real quick? He's not in custody, but I wanted to discuss the motion I filed on him.
Okay. Brandon Coy.
Judge, he's got a pending criminal abuse case, and I filed a motion in the bond conditions. It states that he's supposed to obey all relevant court orders, and I'm kind of using this in the strictest sense, but Officer Alexander contacted me on Friday stating that he's monitoring him for a felony case he's on probation for out of Edmonson County, I believe. And he had sent a notice to the court there that Mr. Coy did not respond, did not call him back. He tried contacting Mr. Coy and sent a letter to an address he had that came back undeliverable. Doesn't know where he's at. And I also noticed the motion itself talks about him not obeying court orders. And I think there's valid cause I was going to ask you for a warrant since we can't find him, and that his charges are pretty serious. And he also has a past history of drug use. But also I may end up supplementing my motion because when I was going through this morning, I did see he had a pending warrant out of, I think it was Edmonson or Butler County, because he's got felony cases, 2 new F cases that I need to look at. I'm kind of confused of when he left the Barron County jail and when he was released at some point at whatever other jail he went at, because that was the issue Officer Alexander was having. He could never locate him.
Yeah.
So
it says
that's
he
why
was released. It says he was released from the Hart County jail on December 8th. I don't know when he went from here to there.
Right. And Officer Alexander included his report saying he can't locate him or find him, and he is in violation. I mean, that is a violation of his conditions. And
Yeah.
I've got a co-defendant in this case we're trying to work out, and I need to try them together. So I'm trying to at the very least locate him and see, if I don't know if he's doing drugs or he's just absconding or what.
It looks like he got out
When he
of,
was released 9/19.
From Barron County Jail.
I was going to say, it looks like he got out of our jail in September and went to Hart County.
And it looks like, Judge, he picked up, and again, I have to supplement my motion, I just noticed it, but he picked up 2 new F cases involving theft. And I think those dates were the October timeframe. I do know he went back to jail at some point. I don't know. I just didn't know about any of this, so I'm still looking at it, but I'm concerned he's kind of out and about with this type of case. We can't find him.
All right, well, it appears that there is probable cause that he has violated at least one condition of his bond. And that's probable cause of a bond violation is justification for a warrant. So he's got a warrant apparently in his probation case in Edmonson Circuit Court.
I believe so.
Judge,
Yes.
just from the available resources I end up having, I end up showing that he ended up leaving Barron County in September. It looks like he was booked in November and released in December from Hart County. So there's that gap that he was talking about for October.
So he picked up a new charge in there somewhere and went back to jail.
That's my understanding, Judge, and I'll
All right.
supplement my motion.
Okay. So we'll issue a bench warrant on that. All right, that'll do it.
Thank you, Judge.
Let's see. Looks like I got Mr. Brown back on here. But now he's just on a phone instead of a.
Yes,
Your
sir.
Honor.
I couldn't get a good connection for Zoom. I tried repeatedly.
Okay.
Your Honor, there's something with Mr. Brown's case I'd like to discuss with whoever is appointed to him, and you off the record.
Okay. Mr. Barry, here's what we're going to do with Mr. Brown. He was on the Zoom earlier. So I did see him, you know, I mean, I wouldn't want to arraign somebody that I'd never met or anything like that on the phone, but I was on the video earlier. I'm going to appoint the DPA to represent him. He's got possession of a handgun by a convicted felon and then paraphernalia and marijuana. If you all want to have a formal arraignment, we can, or you want to waive a formal arraignment, I can hook you all up with a way to or, you know, you all trade you information right now where you all can contact each other and we'll.
It would waive formal arraignment, Judge, and or not guilty plea. We can trade phone numbers.
All right. Why don't y'all go ahead and do that while I'm coming up with a date?
Okay.
Okay, my number's
okay, go ahead.
My number is 270-303-5680.
Okay. Our number is 83. Do you have a pencil there, a pen to write this down?
Yes, sir.
833
Mm-hmm.
385
Okay.
6055.
Okay.
Zanda will be your attorney.
Who is that? Say it one more time.
Zanda, Z-A-N-D-A.
Okay.
Ms. Gardner, is what you're going to ask us, or should I go ahead and set a pretrial conference and then we'll talk about whatever you want to talk about?
Yeah, that's fine.
All right. Let's put a pretrial conference on for March 22nd at 1 o'clock on the 1 o'clock docket. Mr. Brown, you're gonna,
Yes,
to be sure you make contact with your attorney before then, okay?
Yes, sir.
And then she'll let you know, or, you know, just maintain contact with her so we'll know whether you'll be coming in here in person or we'll be meeting in a remote way like this, okay?
Okay. Yes, sir.
All right. Do you have any questions?
No, sir.
All right. We shall see you then, okay?
All right.
Thank
Yes, sir. Thank you.
All right. It looks like also we have Mr. Wheeler on here. He's had posted bond also, and so this court date is this court date was on for an arraignment. I think he was in custody when we set it, but now he's out, so we can go ahead and do the arraignment if that doesn't, if nobody objects.
No, it's fine with me, Judge.
Mr. Wheeler, can you hear me? This works like a dream. Mr. Wheeler, can you hear me? All right. It's not working after all. I don't know what y'all are. Hold the phone here.